Раз.
I think I will introduce a summary, talk about insight. I think God will have a really have on the
Она пропадает иногда.
I think that rights are the rights to which all people are entitled by virtue of being human. Within the large scope of human rights, some rights are considered to be of particular significance. Although certain international instruments permit derogation of these rights in the time of public emergency threatening the life of the nation. All human rights are universal, indivisible, interrelated, interdependent, and mutually reinforcing. And all human rights must be treated in a fair and equal manner, on the same footing and with same emphasis. So it is the first and the main idea that I want to introduce to you, and we will start the presentation here. Here it is. And we will talk about the idea of open societies, and because the idea of open societies is related to the idea of protection of international human rights. Our underlying claim throughout will be that a solid protection of human rights is a necessary condition for societies to be open. What exactly are open societies? Do you feel you live in one? Are you at liberty to do as you wish, and does your society offer you feel freedom? Very few of us would answer this with a resounding yes, and probably many would attempt to answer only partly. And the first to coin the term of society was the French philosopher Henri Bergson. With those words, he wanted to describe the opposite of a closed society. In such a closed society, people only trust their own tribe or group and display hostility and fear towards others. For Bergson, open society was one which could embrace all of humanity. His even more famous colleague, Karl Popper, I think all of you know who is this, and further developed the idea of open societies. Popper defined open societies as places in which individuals are not bound by fixed traditional knowledge or unchanging truth, but are also opening to changing insights and of course knowledge. For Popper, this required a democratic form of government. In his view, democracy was the only system able to channel changes in societies peacefully. It may not come as a surprise, writing as he did during the Second World War, that he saw totalitarianism ideologies such as Nazi communism as example of fatal and dangerous acquisitions. So, going beyond the philosophical idea of an open society, insights from history and the social scientists can tell us more about the idea entails in practice and how this is connected with human rights. So, the rise of the modern state in the past few centuries is an important way marked by the attempt to control a specific territory, the idea of state sovereignty. It was for rulers, or in democracies, for citizens to decide on the rules and laws within their borders. Yet, as the horrors of genocide, ethnic cleansing, and many other crimes against humanity have shown, the idea that states can do as they like is not tenable. Moreover, social scientists have argued that societies that are also open internally and more successful economically and socially. The inclusion of as many groups as possible in the sharing of power and economy wealth is essential. To put it differently, the exclusion and discrimination of the groups, women, ethnic minorities, religious groups, or the poor, is harmful not just to those groups themselves, but also to societies as a whole. Being an open society, therefore, doesn't have ethical but manner. So these insights arose in parallel with the idea of Here you must understand that this idea, the idea of open societies, is existing in a so close connection with the idea of protection of international human rights. And this was exactly the starting point. This idea was the starting point for the drafters of the European Convention of Human Rights, as it is often abbreviated. It was one of the world's first human rights treaties. In the late 1940s, the 10 countries that crafted the convention received the revolutionary document. It is a necessary tool to prevent a return to totalitarianism. It was after the Second World War, so it was the Second World War was like a catalyst for this document. All of these guarantees are laid down in the European Convention. This treaty still forms the foundation of human rights protection in Europe today and also in the world. So it's a good example of the protection of human rights through an international legal instrument. This is why we think it's a good object for study and inspiration, no matter where we live. Also, it's dynamic and in the sense truly open system that is able to meet many challenges that the human rights of all of us face today. So we will turn to the history of human rights and we will see how it all started. In 539 BC, the armies of Cyrus the Great, the first king of ancient Persia, conquered the city of Babylon. But it was his next actions that marked a major advance for man. He freed the slaves, declared that all people had the right to choose their own religion, and established racial equality. These and other decrees were recorded on a baked clay cylinder in the Akkadian language with a kind from script. Known today as the Cyrus Cylinder, this ancient record has now been recognized as the world's first chart of human rights. It is translated into all 6 official languages of the United Nations, and its provisions parallel the first 4 articles of the Universal Declaration of Human Rights. We will talk later about the Universal Declaration of Human Rights because it is an important document for all of us, and not only for Europe, not only for the USA, but for the whole world. And next, international laws are addressed under treaties and states' custom. Practices considered under customary international law and national tradition is omitted from detailed discussion as obviously. It varies from state to state. The most significant impact it has concerns national legal theory and whether state adheres to, for example, a liberal or socialist theory of rights. And we will see another important document. And we will talk about treaties. Vienna Convention on the Law of Treaties of 1969, article number 2, a treaty means an international agreement concluded between states in written form and governed by international law. I want all of you to understand this idea because treaties are the main tools in protection of international human rights. Treaties are formal sources of international law and very common in international human rights law. Simply put, treaties are contracts concluded under international law and thus they are legally binding on states which have agreed to them. As indicated by the Vienna Convention, terminology varies. We can say that treaties, conventions, covenants, protocols, charters, statutes are the most common terms, but irrespective of what the instrument is called, certain common features can be identified. Primarily, most are written. Although oral treaties can exist, no relevant examples pertain to international human rights, and thus the content of the rights and freedoms can easily be identified. Treaties can be also bilateral between 2 parties or multilateral. Treaties are commonly drafted by representatives of all the states. The umbrella organization, United Nations, Council of Europe, and so on, and even representatives of non-governmental organizations. It's also very important because treaties are concluded not only between states. They can be also concluded between United Nations as an umbrella organization and non-governmental organization, and thus beneficiaries of these treaties are people of the world or region, of the certain region. Often an international conference will be convened to allow a wide number of states to debate the proposed terms of the treaty and decide which clauses are and are not acceptable. Such conferences may launch or conclude declared international decades or years, thereby providing greater impetus to the achievement of international consensus of this matter, on this or that matter. The Convention of the Rights of the Child is a prime example. It was adopted at the end of the International Decade on the Rights of the Child. Though the international decades on the world's indigenous people in Congress didn't succeed in producing an agreed text on the rights of indigenous peoples, you can see the chapter number 12, although one of the first texts of the Human Rights Council in June in 2006 partially ameliorated the position. A draft convention was adopted, but subsequently rejected by General Assembly. Treaties may be given a formal name, title, but are frequently referred to by the city in which the text was agreed by the drafting states. Common examples are the Banjul Charter on the Human Rights and People's Rights of the African Union, the San Salvador Protocol to the American Convention on Human Rights, and the Geneva Conventions on the Laws of War. These are the main treaties that the world is demonstrated on the protection of human rights, and other several treaties on different subjects may be concluded in the one city, but thus designating treaties solely on the basis of the treaty, not necessarily definitive. The full title of a treaty may be required for identification purposes. Once a state has indicated its intention to be bound by a treaty, such as at a major international conference launching the treaty, the state representatives will usually be required to return to the respective states and launch in the treaty. So we will see how do states agree to treaties and why do they do this. So treaties are generally signed by a prominent and authorized state or official, see Vienna Convention Article number 7, for who has powers to conclude treaties on behalf of states, to indicate political will to accede to its terms. At this time, the treaty is politically and morally binding on the state. Such a signature is then ratified after the relevant national procedures are followed. National law, particularly the constitutional provisions, determine whether a referendum is required or what steps are necessary to obtain parliamentary or governmental approval of a treaty. So here you can see a QR code. So you have a free connection to Vienna Convention of the Law, and if you want to have a deeper dive into this document, you can scan this QR code and open it on your computers or other devices. So only once an instrument is ratified will it become legally binding on states and thus enforceable. Some treaties don't require ratification, becoming binding solely on signature, in order that the list of states who are bound by an instrument is contemporary. It's normal for states to submit ratification documents to a central body, often the United Nations Secretary General, for dissemination to other states who are already bound by the instrument. The following is an example of a signature and a ratification clause. So when do treaties become legally binding? Here we will see the process. In terms of international law, treaties become legally binding when they enter into force. In other words, they become applicable and enforceable law on that date. Note that treaties only apply to those states which have agreed to be bound by the provisions of the treaty in question. States cannot be forced to comply with a treaty which has not entered into force or which has not been ratified by them. Obviously, political pressure can be and is exerted to secure compliance with certain human rights, for example, through trade aid or aid agreements or so and so on. However, that's distinct from the legal enforcement of treaties. Usually, a clause near the end of the treaty will specify when the treaty becomes legally binding on contracting parties, that is, when it enters into force. This clause in the International Covenant on Economic, Social, and Cultural Rights follows as an example. Treaties may subsequently be amended, often by a device called a protocol. Protocols are simply international instruments added onto a treaty. They're usually optional. So a state may be a party to the main treaty, but avoid obligations under any associated protocol. In the field of human rights, protocols frequently provide additional rights and freedoms. Examples include the two protocols to the United Nations Convention on the Rights of the Child, on the involvement of children in armed conflicts, and on the sale of children, child prostitution, and child pornography. Both protocols were adopted in 2001. Other protocols may provide an optional enforcement mechanism. For political reasons, the enforcement mechanism may have been omitted from the main treaty. The first optional protocol to the International Covenant on the Civil and Political Rights is one of numerous examples. It really shrinks, and so it enshrines a system of individual petitions, which many states have elected not to sign up to or to sign it to. Within the African regional system, the protocol on establishing an African Court of Human Rights was added to the African Charter of Human Rights and Peoples, and it's one of the most important examples in the world's history in protection of human rights and in legal as a legal consequence of NCUR. So we will talk about main principles of international human rights treaties. You can see them on the slide of the presentation, and the following list contains the most common international human rights instruments, but this list is not closed. So there are more and more principles of international human rights treaties and more examples of them, but these are the main. On the slide, you can see the main principles of international rights treaties. So the full text of each instrument can be obtained from the website of the Office of the UN High Commissioner for Human Rights, and you can see them here. For example, the International Covenant on Civil and Political Rights of 1966 is one of the most important and common instruments of international protection of human rights. The International Covenant on Economic, Social, and Cultural Rights, the UN Convention on the Rights of the Child, the Convention on the Rights of Persons with Disabilities, which is quite treaty in the world history, in 2000 and so on. These are the 9 core United Nations treaties. So many other instruments are adopted under the United Nations and its main organs, institutions, organizations, which pertain rights. So we will turn to the issue of overlapping treaty obligations. Often the rights contained within the various human rights instruments overlap. The prohibition on torture is thus found in the UN and European treaties. So on torture, the European, American, African, Arab, and CIS conventions on human rights, the International Covenant on Civil and Political Rights, and the Instrument on Discrimination Against Women, Race Discrimination, Children, and Migrant Workers, to give a few examples. The following list illustrates the overlap of the main international regional human rights instruments. The table reflects which rights from the Universal Declaration of the Table on Human Rights, which is used here as the core standard, appearing with subsequent international and regional instruments. The 2 international covenants, which provide a binding tabulation of the Universal Declaration of Human Rights, and the Convention on the Rights of the Child, which has attracted almost universal ratification, represent the international system. The 3 major regional systems are deployed as examples of regional instruments. Note that the list provides only an approximation of the overlap in rights and freedoms. The regional instruments in Africa and the Americas contain additional rights that are expressly mentioned on the Universal Declaration. Non-discrimination clauses are virtually uniform. All the recent treaties contain more expansive grounds of discrimination. So we will turn to customary international law because it's also an important instrument, and we will see that not all international human rights are located in written treaty, because here on the previous slide we can see only a written treaty, but we also have a customary international treaty, and some rights may be found in customary. What is it? This has some advantages, as not state has signed up to and ratify the international human rights system. Yet, so they still remain bound to some of the provisions of rights. 3 elements of customary international law predate the emergence and premium generic rights. Customary international law finding may have the course of in accordance with the International Code of Justice. The laws by law as evidence of general practice adopted as law and the general or recognized by civilized. You can see the article number 3. Customary international law differs from treaties in that customary international law may not be written down. This is the main difference. Customary international law is written, we have already seen on this slide, on the previous slide here. So, states don't sign up to customary international law or ratify it in convention. We also have some customary guarantees against torture and slavery, and the prohibitions on slavery and on torture are two obvious examples of human rights provisions which transcend the fundamental treaties and now can be regarded as customary international law. Consequently, states are bound to refrain from engaging slavery or torture irrespective of whether or not they have ratified any international rights instruments. As the prohibition on slavery has roots traceable some 200 years back, few states have had the opportunity and none have availed them of it to indicate an intention not to be bound by this norm. Though the United Nations itself is predicated on respect for the dignity and worth of the persons, is the preamble charter of the United Nations of 1945, a respect which clearly presupposes the abolition of slavery. More recent condemnations of slavery and the slave trade, such as those issued at the World Conference against Racism and Related Intolerance in 2001, add further universal support for the customary nature of prohibition. Subsequent review conferences further focused attention on these issues. The number and identity of treaties which the state in question has ratified is irrelevant, as the state is bound purely because prohibition on slavery is so well established that states feel legally bound by it and act in accordance with it. And it is not the last instrument in protection of human rights, so we also have the soft law. In addition to legally binding law enshrined in treaties or reflecting customary practice, international law also has a large body of material known as soft law. Soft law includes an array of different measures which can considerably influence and shape state practice. In a sense, they can be regarded as statements of intent on the part of states. Moreover, they can be important indicators of state practice, thereby contributing towards the evolution of customary law. Key instruments include declarations of international and regional organizations. These can prove to be of extreme importance. The Universal Declaration of Human Rights is the declaration of the General Assembly of the United Nations. As such, it's not strictly legally enforceable, although obviously it's one of moral force and represents the agreed viewpoint of the international community. Moreover, as is mentioned above, some elements of the Universal Declaration are now so widely accepted as to be deemed customary international law. Consider the impact of decolonization throughout the world in the era of the adoption of the following declaration and thereafter. So in order to have a deeper dive into this important instrument, we will see a video on implementing of a soft law, because I think that it is really important nowadays.
Hi, my name is Derek McKee. I'm a law professor at the Université de Montréal, and in this capsule, I'm going to talk about the role of Hi, my name is Derek McKee. I'm a law professor at the Université de Montréal, and in this capsule, I'm going to talk about the role of guidelines in administrative law. As you know, administrative law largely deals with how government officials implement statutes and sometimes regulations as well. But government administration is often guided by informal norms too. These norms have many different names. We can talk about guidelines, policies, directives, operational manuals. Sometimes academics like to use the term soft law as a general description to group all of these together. In general, in this module, I'm going to use the word guidelines, but keep in mind that the exact label is not all that important. Now, what's special about guidelines is that they are not legally binding, but they can still play an important role in public administration and in administrative law. Guidelines are generally seen as a way of promoting consistency in the interpretation of a statute. So imagine a large organization like a government department that administers a complex social program. You might have hundreds of civil servants dealing with individual files and determining how the law should be applied to them. These officials might decide to create guidelines, trying to standardize how they apply the law in certain kinds of cases. The guidelines would then be approved by the minister and would be officially considered as a kind of instruction from the minister to his or her subordinates in the department. They would be seen as a way of helping the minister to delegate his or her authority. So functionally, guidelines may play a role similar to regulations in that they're a way for the executive to flesh out the details of a statute. However, in terms of their legal status, guidelines are very different from regulations. For one thing, unlike regulations, guidelines are not legally binding. They can't be used to impose legal obligations on ordinary members of the public. That's why we talk about soft law. Guidelines are really meant to guide public officials in their work. So a bureaucrat who ignores a guideline could be in trouble with his or her boss, but he or she would not be breaking the law, strictly speaking. Another difference between guidelines and regulations has to do with the source of authority to create them. For the executive to make regulations, it needs an explicit delegation of regulatory authority in a statute. For guidelines, however, that's not the case. There are some statutes that explicitly grant power to make guidelines. You can find a good example of this in the Immigration and Refugee Protection Act at paragraph 159(1)(h), where you can see that the chairperson of the Immigration and Refugee Board is authorized to issue guidelines to members of that board. But more often, frankly, the power is implicit. Often it's just simply the case that government authorities that are responsible for administering statutes are assumed to have the power to establish internal guidelines as to how those statutes should be interpreted and applied. Now, all of this said in terms of the distinction between guidelines and regulations, it's important to look beyond the labels used to properly distinguish, to properly make the distinction. There's a Supreme Court case from 1992, the Old Man River case, that dealt with a federal guidelines order in relation to environmental assessment. And in that case, the Supreme Court looked at the entire statutory context and held that this so-called guidelines order was in fact a binding regulation, despite the name. Another important point that I want to make is that even if guidelines are not themselves legally binding, they can influence the way courts review administrative action, review administrative decisions. So you remember the Baker case, the case in which Mavis Baker's application to remain in Canada on humanitarian and compassionate grounds had been turned down. Well, that was, of course, a discretionary decision. It was a decision made by immigration officers who were acting in the name of the minister. But there were also ministerial guidelines that applied in that situation. Among other things, these guidelines made it clear that immigration officers were supposed to consider the impact of deportation on family members, such as Mavis Baker's Canadian children. But the Supreme Court highlighted the fact that the immigration officers in charge of Ms. Baker's file ignored this guideline. This was one of the factors that made her decision unreasonable. Justice Leroux-Dubé, writing for the majority, wrote that the guidelines are a useful indicator of what constitutes a reasonable interpretation of the power conferred by the section. And the fact that this decision was contrary to their directives is of great help in assessing whether the decision was an unreasonable exercise of the humanitarian and compassionate power. The Supreme Court actually reaffirmed this position that guidelines can be relevant in assessing reasonableness in the 2019 Vavilov case. The majority in that case stated that the reviewing court might consider, among other things, publicly available policies or guidelines that informed the decision maker's work. The court also noted approvingly that institutions also routinely rely on standards, policy directives, and internal legal opinions to encourage greater uniformity and guide the work of frontline decision makers. So, on the one hand, administrative decision makers can't ignore guidelines. But on the other hand, administrative decision makers have to be careful not to follow guidelines too closely. There's an example of this problem in another Supreme Court case dealing with humanitarian and compassionate exceptions, the Kantasamy decision from 2015. In that case, the Supreme Court overturned the refusal of a humanitarian and compassionate application because it found that the officer had followed the guidelines too strictly, treating them as if they were a binding rule and thereby fettering her discretion. This same type of issue, excessive rigidity with respect to the application of guidelines, might also give rise to an issue of procedural unfairness or bias. If you imagine an administrative tribunal where there are multiple tribunal members, each hearing particular cases and deciding them on their merits, if the chair of that tribunal were to issue guidelines that essentially forced tribunal members to decide certain kinds of cases in a certain way, that could conceivably violate the rule, she who hears must decide, which would be contrary to the audi alteram partem principle. Depending on the circumstances, it might also end up being considered a form of institutional bias, which would be contrary to the nemo iudex principle. Now, I've covered some of the legal issues that arise from the use of guidelines, but to end this capsule, I just want to return to an issue that I alluded to at the beginning, which is why is it that government departments and other entities use guidelines? In order to answer this question, one has to consider the alternatives. On one hand, guidelines can be seen as an alternative to open-ended discretion. So from this perspective, guidelines have the advantage of promoting consistency. Remember that statutes are sometimes drafted in broad general language, leaving the details to be filled in later. So it might be preferable to know that different decision makers within an organization are interpreting the statute in roughly the same way, and guidelines can help them to do that. On the other hand, guidelines can be seen as an alternative to regulations or other kinds of hard law. From this perspective, guidelines have the advantage of flexibility. They're easier to change and they don't require any formal process. In a 2007 case called Damodaram, one of Canada's great administrative law judges, John Evans of the Federal Court of Appeal, explained the use of guidelines as follows. He said, "Effective decision-making by administrative agencies often involves striking a balance between general rules and the exercise of ad hoc discretion, or to put it another way, between the benefits of certainty and consistency on the one hand, and of flexibility and fact-specific solutions on the other. Legislative instruments, including such non-legally binding soft law documents as policy statements, guidelines, manuals, and handbooks, can assist members of the public to predict how an agency is likely to exercise its statutory discretion and to arrange their affairs accordingly, and enable an agency to deal with a problem comprehensively and proactively rather than incrementally and reactively on a case-by-case basis. Through the use of soft law, an agency can communicate prospectively its thinking on an issue to agency members and staff, as well as to the public at large and to the agency's stakeholders in particular. Because soft law instruments may be put in place relatively easily and adjusted in the light of day-to-day experience, they may be preferable to formal rules requiring external approval and possibly drafting appropriate for legislation. So what Justice Evans is saying here is that guidelines may provide a useful middle ground between legislated rules and administrative discretion. If used well, they can combine the advantages of both. However, as we have seen in this capsule, they can also give rise to their own sets of challenges.
So I think that you now have a better understanding of the soft law as an instrument of. Have any questions on the video? Ask them now or after our lecture. And are there any questions? Okay, then we can turn to key concepts of protection of international human rights, and you can see them on the slide. And as with so many legal systems, there are certain principles undermine those rights and govern their. So for rights, they are universal and inalienable. Thus, everyone is entitled to rights and demand freedom. And the first concept and the for international rights, valid. Second, Universal Declaration of Human Rights. So, it states that all human beings are free and equal. They are endowed with reason and conscience. They act towards one another, spirit, brother. The text is valid rights theory. Single statement instruments always benefit rights terms such as everyone, and nevertheless, and this is obviously the idea of rights as strongly verified and instantly applicable. That rights are universal. And it is the key concept of and the basis for protection of human rights. And the second concept that you can see on the slide is non-discrimination in the application of human rights. So I want to start with the idea that no one is excluded from the ambit of human rights instruments. Human rights extend equally to children and adults, prisoners, terrorists, all racial groupings, men and women, educated and no educated, and so on. So no one is excluded from the ambit of human rights. Some rights are, however, restricted in the sense that not everyone can exercise them. Rights to marry, for example, don't apply to young children. As this uniform, there is no discrimination. The non-discrimination clauses common to most instruments make the principle of non-discrimination abundantly clear. And the next fundamental principle and the next key concept is interdependence and indivisibility. So I will show you the slide in order to have a deeper dive into this concept, the interdependence. The major international instruments clearly prescribe a wide range of human rights, assuming they are all universally applicable. Are they all equally applicable, or is there an overt or covert hierarchy? Are some rights more important than others? Perhaps most obviously the right to life has to be accorded some degree of paramountcy, even if only as a matter of practicality. Quite clearly, life is a precursor to enjoyment of any human rights, albeit some discussion remains as to the point at which love begins, birth or conception. Thereafter, their importance ascribed to rights is a matter of individual preference. People suffering in the aftermath of a catastrophic natural emergency will most likely prioritize clean and right to vote in democratic elections. Political prisoners may value freedom of expression over liberty. Indeed, some people value freedom. So we will continue with the idea that the theories such as Marxism or communism emphasize many elements of economic and social rights. The state assisted the population with their basic needs. Of course, such rights came at a cost, and many people living in such countries were arguably denied civil and political rights, such as freedom of expression and democratic rights. But in contrast, other side proverbial Iron Curtain emphasized civil and rights, the concepts are so many, very many of these rights were not declared. And for example, they also be tracked to the Reformation and Enlightenment period in Europe. The French Declaration, for example, of the Rights of Man, the American Declaration of Independence, and its amendments, the Bill of Rights, focus on individual freedoms of liberty, speech, and equality. Such rights are primarily civil and political in essence. When the United Nations was preparing the legal tabulation of the Universal Declaration of Human Rights, the onset of the Cold War forced the division of the Universal Declaration, and two international covenants emerged, one on economic, social, and cultural rights, the other on civil and political rights. Even today, there remains a slight difference in the number of states parties to each. A further factor to consider the overlap between rights thus the interdependence of all rights. For example, failure to secure the right to adequate health care, a social and economic right, may result in a threat to life, the right to life being a primary civil and political right. Many more examples can be found. Right to education and right to vote and political participation. Right to adequate rest periods for workers and freedom from degrading and even life-threatening treatment. So the following raise the interdependence of rights focused on the right to water and adequate sanitation on this slide. And access to clean water and sanitation clearly has a bearing on a number of other rights. As a standalone right to adequate sanitation would ensure that elements of the right to sanitation or the right to health are satisfied. On the other hand, fully implementing the right to health would require the supply of water and adequate sanitation. So you can see the table on the slide of the presentation have what I'm saying about. So life, and thus the right to life, is clearly a fundamental requisite to the exercise of many of the other rights and freedoms. However, this doesn't mean that the right to life is totally sacrosanct, that it would place unrealistic burdens on the state to preserve all life. Rather, each instrument knows that instances in which life may be forfeit. So, and here you can see the family of rights. Having addressed the issue of a hierarchy of rights, now consider the extent to which the following three rights and freedoms overlap. Is it possible to have full political participation without at least some freedom of expression? Can education and freedom of expression be mutually exclusive? Does an education of whatever kind assist with participation in the political process and the exercise of associated democratic rights? Rather than consider rights in diverse categories, it is perhaps best to consider them as aggregate important function, each contributing to of rights and freedom. So, human rights don't exist in a vacuum. Inevitably, they are formulated by individuals and states, and they are implemented by states themselves. However, a number of national, regional, and international bodies exercise responsibility for overseeing the monitoring of human rights and ensuring that states comply with their obligations. And we will talk about international organizations that perform as the main instruments in protection of human rights. International human rights are by definition global in character. They apply to all individuals and transcend national law and regulation. As such, they were developed under the auspices of the international community, although they apply nationally. To assist in this, a number of international organizations created norms of human rights and structures for their realization. Predominant among them is the United Nations. Firstly, about it. The United Nations is the primary international organization enjoying responsibility for international human rights protection. However, human rights protection was not the driving force behind the creation in 1945. The purposes of the United Nations are to maintain international peace and security, and to that end, to take effective collective measures for the prevention and removal of threats to the peace, and for the suppression of acts of oppression or other breaches of the peace, and to bring about by peaceful means and in conformity with the principles of justice and international law, adjustments or settlement of national disputes or situations which might lead to a breach of the peace. The second main purpose of the United Nations is to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, and to take other appropriate measures to strengthen universal peace. The third key purpose is to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion. And the last but not least is to be a center for harmonizing the actions of nations in the attainment of common needs. As is apparent, the maintenance of international peace and security is the primary function of the United Nations. However, in furtherance, the role of respect for human rights is identified as being of importance, grounded in the work of the League of the then international community way of the option that securing respect for equal rights would inevitably lead to a more peaceful world. The emphasis on economic cooperation resonated with post-war contemporary politics. Large swathes of the European population were displaced and its economy was in disarray. How does it work? We'll see how the United Nations really works. In accordance with the Charter of the United Nations, Article number 7, the principal organs of the organization are General Assembly, a Security Council, an Economic and Social Council, a Trusteeship Council, and the International Court of Justice and the Secretariat. Of these, the Trusteeship Council is obsolete with the successful transition to independence of the non-self-governing territories. General Assembly. The General Assembly is the principal forum for the congregation of the United Nations member states. It consists of all the members of the United Nations, each member having one vote. The General Assembly has adopted many resolutions which impact significantly one of the work of the United Nations and human rights. Indeed, much of this responsibility for human rights ultimately relates back to or is initiated by General Assembly. All human rights bodies ultimately report to the General Assembly. Even the Security Council must submit annual reports to the Assembly. Consider resolutions of General Assembly is the resolution number 45, Basic Principle for Treatment of Prisoners, United Nations Rules for the Protection of juveniles, Declaration of the Rights of Persons Belonging to National or Ethnic, Religious and Linguistic Minorities, and the Declaration of the Elimination of Violence Against Women. These are the main general. So, as the above list indicates, General Assembly resolutions can and do address a wide range of issues of relevance to human rights. Many elements of freedom of liberty and right to a fair trial are governed by General Assembly guidelines. The importance of these guidelines are that they apply to all the states. Human Rights Council. Not to be confused with the Human Rights Committee, a body established to monitor the International Covenant on Civil and Political Rights. The Human Rights Council is the newest human rights body in the United Nations system. It was created in 2006 to replace the Commission on Human Rights. The Council is tasked to meet throughout the year, a change for the annual meetings on the former Commission. It operates under the normal rules of procedure for committees of the General Assembly and can draw on the skills and knowledge of a wide range of bodies. The Council is tasked to meet throughout the year and change from the annual meetings of the former Commission. It operates under the normal rules of procedure for committees of the General Assembly and can draw on the skills and knowledge of a wide range of bodies. And another important body is Economic and Social Council. And Article number 61 of the Charter of the United Nations provides that the Economic and Social Council shall comprise 54 members of the United Nations. This represents the culmination of a series increases from the original 18 agreed in 1945, each serving 3-year terms of office. A wide mandate is extended to the Council, thereby facilitating its evolution into a key player in contemporary international human rights law. Delegation is pivotal to the completion of the work of this body, and it has created a number of commissions and specialist committees and appointed various expert bodies to assist in the discharge of its broad range of functions. At present, Economic and Social Council has 9 functional commissions, many of which impact on human rights. Functional commissions of international human rights, Economic and Social Council, are the ANU, Commission on Population and Development, Commission for Social Development, Commission on the Status of Women, on Narcotics and Drugs, on Crime Prevention, and United Nations Forum on Forests. Another body is the Commission on the Status of Women. This economic resolution of 1946 established the Commission on the Status of Women. Membership has increased to 45 with a clear balance in favor of women members. Unlike most of the international human rights machinery, the Commission on the Status of Women Secretariat, partially provided by Division for the Advancement of Women. The functions of the Commission are governed by the powers granted to it and enabling resolution. This was expanded in resolution number 97, and as of in 2008, to and elimination of discrimination against bodies allocated in one city. However, one session each year is still held in New York. The most significant body of work before the Commission at present is the ongoing review of progress towards the goals agreed in Beijing by the First World Conference on Women in 1995. And we are turning to international courts. So there are 2 international courts, neither of which actually has cause to consider international human rights on a regular basis. The International Court of Justice is part of the United Nations and is established in accordance with the Charter of the United Nations itself. And the other court is the International Criminal Court, is independent of the United Nations machinery, yet accepted by many member states. And it is a peculiar hybrid body. Although operating within the ambit of international law, it sought solely to prosecute individuals for violations of selected, very serious elements of national humanitarian and criminal. Another important organization is the International Labour Organization. It remains despite the collapse of the League of Nations. Today, it is officially a specialized agency of the United Nations. In furtherance of its remit, the ILO has adopted a range of conventions and recommendations aimed at a standard-setting international labor law and policy. Its success in setting an agenda for labor standards over 90 years has been remarkable. Yet its work is often overlooked in favor of UN treaties. So, we also have regional organizations that also work for protecting human rights. And we will start with Europe, and we will talk about the Organization of Security and Cooperation in Europe. The Organization of Security and Cooperation in Europe was established as a permanent diplomatic conflict to maintain peace and stability in Europe. At the time, the region was fractured ideologically with the Soviet bloc and the Eastern areas. It was one of the major political achievements of the Cold War era. Not only did states from both sides of the Iron Curtain sit down together to discuss common aims, but human rights was high on the agenda from the outset. Admittedly, many areas of crucial importance reflecting a partial decline were also included. Prior notification of military maneuvers, for example, and with some 56 member states, it's one of the most geographically widespread of Europe's regional systems. Though note that Canada and USA, key members of NATO, are also members. So on this slide, you can see how the Organization of Security and Cooperation in Europe really works. And we turn to European Court of Human Rights. The European Court of Human Rights is probably the most effective court yet established to monitor and implement human rights. Its impact extends beyond Europe, as various national courts in other regions of the world have recourse of the European Court on Human Rights when determining the nature and scope of certain continuous rights. On particular note, all contracting states must permit individual complaints to be brought before the European Court of the Human Rights. You can see how it really works. The court may receive applications from any person, non-governmental organization, or group of individuals claiming to be victim of a violation by one of the high contracting parties of the rights set forth in the convention or the protocols thereto. The high contracting parties undertake not to hinder in any way the effective exercise of this right. The court may, at the request of the Committee of Ministers, give advisory opinions on legal questions concerning the interpretation of the convention. Note that no reporting systems operates from the European Convention on Human Rights. All the reports are the principal mechanism to deploy it for ensuring compliance with the European Social Charter. Despite the terminology, the European Court on Human Rights continues to regard its function as supervisory. This is, it seeks to guide states in their application of the convention. There is copious evidence of this. The court rarely awards quantitative damages as just satisfaction. The court will determine a violation and rarely proceeds to elaborate on subsequent articles of the convention, which may also have been infringed. And now we will see the video, the correct way to lodge an application.
Like tens of thousands of people every year, you are about to lodge an application with the European Court of Human Rights. First, make sure your application meets all the admissibility criteria, in particular that you have raised your complaint before all the relevant courts in the country concerned, and that you are within the deadline for lodging your complaint with the court in Strasbourg. In lodging your application, there are certain formalities you must comply with. Otherwise, there is a risk that the court will not examine your application. Download the application form that is available on the court's internet site and fill it in completely and without using any abbreviations or symbols. Please note that a form which is incomplete will be rejected, so make sure you follow these instructions very carefully. Fill in all the parts of this page which concern you. If you are represented by a guardian or a member of your family, or by a lawyer, fill in the relevant parts of the form. It is essential that you sign the power of attorney. Specify the state or states against which you are lodging your complaint. They must be states which have ratified the convention. Here is a list of those states. Give a brief description of the facts, if possible no longer than 3 pages. Explain clearly, in chronological order, the events which led to the alleged violation of your rights. Indicate which articles of the convention you consider have been violated. For each convention article you mention, in turn, briefly explain how that article was violated. For each complaint, that is to say, each violation you complain of, indicate what action you have taken before the domestic courts and what remedies you have attempted. Make sure you state the dates of the decisions given in your case and the dates on which you were informed of those decisions. Fill in this part of the form only if you have not exhausted all the possible remedies the national legal system offers, or if you have brought a case before another international body. If you have already brought a case before the European Court of Human Rights, indicate the corresponding application number. You must send the court copies of all the relevant decisions and documents. Arrange them in chronological order, make a list of them, and number them. Do not send any originals, as no documents will be returned to you. When you have finished filling in the form, print it out, date it and sign it, and send it to the court by post only, together with copies of the necessary documents. If your form has been correctly completed, the court will examine whether your application is admissible, and if so, examine the merits of your complaint. However, if your form has not been correctly filled in, or if you have not enclosed the necessary documents, the court will not examine it. To help you fill in the application form as accurately as possible, please read the reference documents the court has prepared to guide you step by step.
And we are turning to other regional organizations, for example, the Organization of States and rights work on undertaken by institutions established the rights. These are discussed in chapter number 6. However, there are also impacted kinds of human rights. Most notable is the in Africa, in the Durban Summit of the then Organization of American Unity, and interim arrangements remain at present from the Organization Union. The African Union now comprises various organs: the Assembly, the Executive, an African Parliament, the African Commission, the Permanent Representative Committee, the Specialized Technical Committee, the Economic, Social, and the Peace and Security, and various financial institutions, of course. Most of these institutions are in early stages of operation at present, and their impact remains to be seen. Another important United Educational, Scientific, and Education. So the United Nations Educational, Scientific, and Cultural Organization also operates a non-continuous individual communications procedure for violations of education, culture, and science rights. Given that the process operates under the auspices of the United Nations Educational, Scientific, and Cultural Organization, it naturally applies to a limited range of rights, essentially those falling within the competence of the body. In terms of the Universal Declaration of Human Rights, these rights include the right to information, including freedom of opinion and expression, the right to education, the right to participate freely in cultural life, and the right to scientific advancement. This body notes that these rights may imply the exercise of other rights, such as freedom of thought, concise in religion, the right to receive and impart information and ideas through any media, regardless of frontiers, moral rights resulting from scientific, literary, or artistic production, and freedom of assembly and association of activities related to education, science, and culture. The process was established by a decision adopted by the Executive Board of the United Nations Educational, Scientific, and Cultural Organization in furtherance of the duties incumbent upon the organization in terms of its constitutive document. So another important regional organization, Regional Court, International Criminal Courts, Tribunals, and Processes. So, while technically not international human rights, but rather international criminal law has evolved, made clear that individuals may be prosecuted for a very serious infringements of international human rights. International criminal law builds on the work of the Nuremberg and Tokyo tribunals established after the Second World War, and more recently the work of the two International Criminal Tribunal. Mixed courts are primarily established under domestic law with the purpose of examining atrocities committed within the state. They usually apply national and elements of national criminal law. While not necessarily part of the international system, they merit brief consideration as their increasing number was perhaps a factor contributing towards the development of the permanent international criminal law. And a substantial portion of continental criminals was of these, and these procedures became viewed as a necessary part of post-conflict nation building, rebuilding. The potential for increased costs was dramatic. To many commentators, the mixed courts were thus a cost-saving initiative. Note, however, that this of the International Criminal Court is concerned with national courts. Thus, the potential for further mixed courts and tribunal remains. And we will talk about key concepts for courts and tribunals. You can see them on the slide. Firstly, we will talk about fair trial. The right to a fair trial is one of the most heavily litigated human rights. Within the Council of Europe, and the majority of cases before the court involve Article number 6, the right to a fair trial. Click something in chat. Thank you. So we will continue with fair trial, and the modern definition of a fair trial also finds expression in the statute of the International Criminal Court, which indeed provides one of the most detailed tabulations of the right to be found in international human rights law. So another key concept and another principle is an access to a court. The European Court of Human Rights created an early precedent by articulating the actual rights of an access to a court. This may seem axiomatic, but without an access to a competent court, the fairness of any trial is obviously a moot point. This also raises issue of legal identity and recognition as a person before the law, thereby facilitating an access to a court. Judiciary, fundamental to the concept of the rule of law and to the principle of separation of powers between the three principal elements of case, executive, judiciary, and legislature, is the need for a fair and independent judiciary. Independence is required from political, economic, and other external influences. Judges should remain influenced only by the application of the law to the facts arising in the case before them. More detailed provisions can be found in the statute of the International Criminal Court, which, though obviously restricted to the International Court, in application provides an indication of the prevailing international standard. So, it's all that I wanted to tell you about international human rights today, and now we will have a quiz. So you can answer here in chat, or you can on your microphone and say the right answer. So we will start with the first question. Here it is. You can see it on the slide of the presentation. What can be defined as human rights? A simple question. As for me, you can text in the chat or turn on your microphone and video if you want. I see your answers in the chat. See. Okay, let's turn to the right answer. And you can find it here. Yes, the right answer is C. Of course, as we said earlier in their page, these rights are inherent to all human beings, whatever our nationality, place or residence, sex, national or ethnic origin, color, religion, language, or any other status. We are all equally entitled to all human rights without any discrimination. These rights are all interrelated and interdependent and indivisible. So universal human rights are often expressed and guaranteed by law in the forms of treaties, customary international law, and general principles and other sources of international law. So yes, the right answer is C. These are rights inherent to all human beings. And the next question, what makes the Universal Declaration of Human Rights so unique? A, it was drafted by people from all over the world. B, sets common standards on human rights protection. Or C, both previous answers. So let's check the right answer. What makes the Universal Declaration of Human Rights so unique? Maybe it was drafted by people from all over the world, or it sets common standards of human rights protection, or both of these answers are right. What do you think? I see the first answer, C. Does anyone want to try to answer this question? C, okay. And C, okay. Let's check the right answer. And the right answer is C. The Universal Declaration of Human Rights was drafted by representatives with different legal and cultural backgrounds from all regions of the world, and then proclaimed as a common standard of achievements for all peoples and all nations, setting out for the first time fundamental human rights to be universally protected. So yes, it's C. You are absolutely right. And another question. Which article gives the right to a fair trial? It's a more difficult question, but if you know the right answer. The right to a fair trial is one of the most heavily litigated human rights. And can you find the number of articles that gives the right to a fair trial? The first answer is the article number 6. Okay. Article number 6. Article number 6. Okay, I think that it's time to check their answer. Yes, you're right. You're absolutely right. Article 6 protects your right to a fair trial. It also ensures you have an access to the courts and gives you the right to bring a civil case. And I want you to understand that the modern definition of a fair trial also find expressions in the state of the International Criminal Court, and which indeed provides one of the most detailed tabulations of the right to be found in international human rights law. It was the last question from my side. If you have any questions for me, you can write them in your chat or turn on your microphone and ask them. I will be really glad to answer. Does anyone has a question? I will stop the screen demonstration so you can ask me. No, thank you. Thank you. I see that there are no questions from your side. I have a question. Oh, great. About the video showed in the lecture about the legal process. It was about what process? It was about the process of when you want to applicate to the European Court of you have a special process. So this video showed you the right process of the application to European Court of European Court. So in order to protect your it will be send you this video because it's really know how to the application to the European Court of Human Rights, because it is probably the most effective court yet established to monitor and implement human rights. Its impact extends beyond Europe, as various national courts in other regions of the world have recourse to the European Court of Human Rights. So you must know how to give an application, how to applicate there. I think that yes, it will be important to send you this video, or you can try to find it on YouTube. On YouTube. Nothing for. So complicated. Is ordinary person can easily follow the process, or do they usually hire the attorney? Yes, it's a very good question. Yes, the process is really complicated. It's complicated only because the European Court of Human Rights is the highest court in the hierarchy of national courts. So I think that an ordinary person can follow the process, but I don't think that they can do it easily. But with the help of special sources and with the help of lawyers, one can do it. But I think that from my point of view, it's not such an easy process that you can do it only yourself. Yes, it's really complicated because you have to bring dozens of documents and dozens of evidence in order to protect your human rights in European Court of Rights. And yes, they usually hire the attorney and the help of course in order to give an application to the European Court of Human Rights. Is everything clear here? The European Court of Human Rights is the European organ. So there are many bodies. There are many bodies that offer free legal consultation. So you can, if it's a refugee or the man in poverty, it can have a help from the free body of the free lawyer in his state. Because, for example, in Russian Federation we have lots of bodies that offer free consultations from lawyers and attorneys, and I think that in every state and in every country there are such lawyers and attorneys that offer free consultations and free help in such cases. I don't think that it is also always expensive, so you can do it for free. You can ask for this help for free. Nothing for. Thank you, Amy. Very interesting questions. Are there any questions? Okay, I think that everything is clear now. Great. So thank you for this productive evening, and thank you for being here. I think that we're all for now. Thank you in advance.